Textbook of Legal Studies XII 2023-2024. www. CBSE Academic. NIC. In 53. Unit I. Unit 2 UNITIII Unit IV. UNITV. Unit V Unit 7 Unit V. Law of Contracts. Learning outcome students will be able to understand the formation of agreements and contracts. Understand the essential elements of a contract. Distinguish between the types of contracts based on enforceability. Understand and analyze illegal, void and voidable agreements. Elaborate the process of discharge of contract. Critically analyze the remedies awarded for breach of contract as damages. Amritlal was in need of 5 kilograms rice and exchanged them for 10 kilograms mangoes with his next door neighbor to avoid going to the market. He soon realized that he has given a rare commodity, as it was not the mango season, at a cheap exchange. It has been a common practice to exchange things of utility in the ancient times. However, with the advent of money as a common medium of exchange that is fair and uniformly valued at a given place, it has become easy to enter into transactions that are definite. In the modern times, these definite transactions are known as contract. The contracts regulate the business transactions among parties placed both domestically and internationally. A. Introduction to contracts. Contracts are an important part of commercial law because all commercial law transactions usually begin with an agreement or a contract. To understand the concept, we may take example of some of our everyday activities like buying groceries, booking a cab, eating at a restaurant, paying for internet, purchasing clothes in a sale or otherwise and likewise. These business transactions involving sale, purchase or exchange of services have become an integral part in day-to-day activities that involve contracts. In such instances, an agreement or a contract is necessary for determining the rights, obligations and liabilities of parties when they enter into any business transaction. The Indian Contract Act is the law governing contracts in India. B. Formation of contract. According to the Indian Contract Act, 1872, referred to as the ICA, an agreement that is enforceable by law is a contract, Section 2, H. This implies, all agreements per se are not contracts. Agreements must meet certain criteria stated as under. An agreement is the result of a proposal or an offer by one party and its acceptance by the other. 1. Competent parties. The parties to the agreement must be competent to enter into a contract. 2. Lawful consideration and lawful object. There must be lawful object and lawful consideration in respect of the agreement. 3. Free consent. There must be free consent of the parties that is free from coercion, undue. Chapter 3, A. Textbook of Legal Studies XII 2023-2024. www. CBSE Academic. NIC. In. Unit I. Unit 2. UNITIII. Unit IV. UNITV. 54. Unit V Unit 7 Unit V. Influence, fraud, misrepresentation and mistake, when they enter into the agreement. 4. Not expressly declared as void by the law, the agreement must not be the one, which has been declared as void by the law in force at the time of entering into the agreement. It is therefore true by virtue of provisions of Section 10 ICA that all contracts are enforceable agreements, while the vice versa may not be true when an agreement is not enforceable by law for want of lawful consideration or lawful object. Thus it is correct to generalize that all contracts are agreements but all agreements are not contracts. C. Intention to contract in a leading case. Balfour v. Balfour, 1919, 5 kilobytes 571, the validity of an agreement entered between a husband and wife was in question. The husband and wife went on leave to England and the wife fell ill in England. The doctors who treated the wife advised her to take full bed rest and remain in England in order to continue the treatment. The wife stayed in England. When the leave was over, the husband went to Saloni where he was employed and promised to send a sum of £30 to the wife every month for her stay in England. He sent the amount for some time, and later on, due to differences and misunderstanding between them, the husband stopped sending the amount. The wife initiated action to recover the arrears due to her. The court dismissed it on the ground that the agreement entered into between the husband and wife was not a contract. The arrangement between the husband and wife was only a moral obligation, and the parties never intended to create any legal relationship. The decision clearly shows that agreements that create a legal obligation are only contracts, and those agreements that do not intend to create legal relationship are not contracts. Offer, proposal and acceptance. The offer or proposal is the first step in the formation of a contract. When one person signifies to another his willingness to do or not to do certain things, it is called an offer. Section 2(a) of ICA. The person making the proposal or offer is called the offerer, and the person to whom the offer is made is called the offeree. The offer given must be with an intention to create a legal relationship. An assent or consent given to an offer by the offeree is known as acceptance, Section 2(b) of ICA. By saying, yes, okay, or clicking on, I agree, on an offer on a website also amounts to acceptance. An offer when accepted becomes an agreement. An agreement is also called as promise. Offer plus acceptance equals agreement. Illustration. A expresses his willingness to sell his cottage to B for Rs. 5 lakhs. Here, his willingness is called offer. A is the offerer and B is the offeree. B accepts the offer to purchase the cottage. This is called acceptance. A's offer when accepted by B becomes an agreement. An offer and acceptance must be definite and certain. If the offer or acceptance is not clear enough to conclude a contract, it is considered invalid. Also, an offer and acceptance must be communicated to the other person in order to be valid. A communication in electronic form or over emails also amount to communication of offer and acceptance. An offer lapses by revocation or withdrawal. Any offer can be revoked before acceptance. General offer. In an English case, Carlyle vs. Carbolic Smoke Ball Company. 1893, 1 QB 256, the company was the manufacturer of a medicine called smoke ball which was used for the treatment of influenza. The company believed that the medicine completely cured influenza. An advertisement was put up, Textbook of Legal Studies XII 20232024. www. CBSE Academic. NIC. In 55. Unit I. Unit 2 UNITIII Unit IV. UNITV. Unit V Unit 7 Unit V. Offering a reward of £100 to anyone who got influenza again after using the smoke ball medicine continuously for 15 days. In the advertisement, it was also stated that £1,000 was deposited in a bank, namely, Alliance Bank, for paying the reward if such situation arose. Seeing the advertisement, Mrs. Carlyle bought the smoke ball medicine and used it as per the directions provided. Mrs. Carlyle got a fresh episode of influenza. Mrs. Carlyle sued the company for the reward of £100. The manufacturing company stated that, 1. There was no intention to enter into a legal relationship with anyone through the advertisement, and the advertisement was put up only to boost the marketing of the smoke ball medicine. 2. The advertisement was not an offer as it was not made to any particular person, and an offer cannot be made to the public at large or to the whole world. 3. Acceptance by the offeree had not been communicated, and so there was no binding contract. The court rejected these contentions of the company and allowed Mrs. Carlyle's claim for £100. The court also stated that deposit of £1,000 in the Alliance Bank by the Smoke Ball Company was evidence that the company had real intention to enter into a legal relationship with anyone who accepted the offer. An offer can also be made to the world at large. It is called a general offer and it is valid. In the case of general offer, there is no need for communicating acceptance to the offerer. Merely fulfilling the conditions of the offer itself is treated as acceptance to create a contract. D. Consideration. Consideration is an important element in a contract. A contract without consideration is not valid. Consideration means something in return for the offer. Consideration can be in the nature of an act or forbearance. The general rule is that an agreement without consideration is void and not enforceable by law because in such cases, one party is getting something from the other without giving anything to the other. There should always be a mutual consideration. In other words, each party must give and also take. There are exceptions to this general rule in certain situations, such as a written and registered agreement out of natural love is not void, even if it is without consideration. Consideration need not be adequate, but should be real. It may be past, present or future and should not be illegal, immoral or opposed to public policy. Illustration. A offers to sell his car for $50,000 to B. B accepts the offer. In this case, the consideration of A is his car and the consideration of B is $50,000. Illustration. A, for natural love and affection, promises to give his son, B, $1,000 to B in writing and registers it. This is a contract and absence of consideration does not make it void. In an Indian case, Durga Prasad v. Baldeo, 1880, 3 all 221, the plaintiff constructed some shops at the request of the district collector in a town. The constructed shops were given on rent for doing business to the defendant, the shopkeeper. The defendant, apart from the rent, promised to give 5% commission to the plaintiff on all articles sold through the shop in consideration of the huge amount spent by the plaintiff in the construction of the building. The defendant failed to pay the commission and the plaintiff initiated action to recover the commission. The court rejected the action of the plaintiff on the ground that the construction of shop was done at the desire of the district collector and not on the desire of the defendant, and hence there was no consideration to give commission. Accordingly, there is no valid contract to pay commission to the plaintiff. A. Capacity to contract. One of the essentials of a valid contract as mentioned under Section 10 ICA is that the parties must be competent to contract. Following are not competent to contract: minor, persons who are less than 18 years of age; persons with unsound mind; persons disqualified by law, alien enemies, foreign sovereign etc. Textbook of Legal Studies XII 2023-2024. www. CBSE Academic. NIC. In. Unit I. Unit 2. UNITIII. Unit IV. UNITV. 56. Unit V. Unit 7. Unit V. Who is a minor under Indian law? It was the Indian Majority Act that laid down the age of majority as 18 years, except in cases where guardian has been appointed by the court, it was 21 years. An amendment to the said Act has amended the majority age to 18 years for all cases. Illustration. A. Major, offers to sell his coat for $3,000 to B. Minor. B accepts the offer and pays $3,000. A states that the contract is entered into with a minor and hence void. In this case, even if the contract is entered into with a minor, it is enforceable because it is beneficial to the minor and the minor has performed his part of the obligation in the contract. Interesting facts. A minor is incompetent to contract because he is below 18 years of age. Indian Contract Act does not answer whether an agreement by a minor is void or voidable. Nature of minor's agreement has been analyzed by the courts from time to time based on the facts and circumstances of the case in light of general principles of equity and natural justice. Initially, the controversy was set at rest by the decision of Privy Council in Mohori Bibi vs Dharmodas Ghosh. The minor plaintiff mortgaged his property in favor of the defendant, who was a money lender, to secure his loan. The money lender had knowledge about the minority of the plaintiff. The court held against the contentions of the defendant that no estoppel could apply against the plaintiff, as both the parties were aware of the minor's minority. Also, the defendant asked for the refund of loan taken under the provisions of ICA if mortgage is cancelled. Court held that an agreement by a minor is void ab initio. In another case, Kaluz Mittelbackert vs East India Hotels Limited. There was a contract between Lufthansa, a German airline, and Hotel Oberoi, New Delhi, that crew of the airline will stay in Lattice Hotel. The plaintiff, a co-pilot of the airline, stayed in the hotel and sustained serious head injuries on diving in the swimming pool of the hotel. This resulted in paralysis, and after a battle of 13 years with his health conditions, he died. Though he had no direct contract with hotel, but he succeeded as a beneficiary and was awarded compensation for the damage caused. Being a 5-star hotel, extra care and caution was expected out of the hotel, and thus exemplary damages of 50 lakh were awarded. F. Consent. Consent is an important criterion while entering into a contract. When two persons agree on the same thing in the same sense, consensus ad idem, it is termed as consent, section 13. Consent should be free and not caused by coercion, undue influence, misrepresentation, fraud, or mistake. If consent is obtained by the influence of any one of the above said, then the consent so obtained is not free. It becomes voidable, a void enforcement of contact, for the person whose consent is not free. Illustration. A threatened to kill B if he does not sell his house to A. B out of fear signs the contract for selling his house to A. Here, the consent of B is not free. B can later avoid the sale on the ground that he was compelled to agree to the sale and the consent given was not free consent. G. Types of contracts, agreements. As discussed above, all agreements may not be contracts and vice versa. There are situations when agreements turn into contracts at their inception, but at a later stage, due to change in any of the essential conditions of a contract ceases to be enforceable under the law and thus becomes void at the option of any of the parties to the contract. Also, when the consent obtained for the agreement is not free, it is voidable. The concept of validity or enforceability of a contract is not defined in Indian Contract Act, however. Textbook of Legal Studies XII 2023-2024. www. CBSE Academic. NIC. In 57. Unit I. Unit 2 UNITIII Unit IV. UNITV. Unit V Unit 7 Unit V. Is through the various judgments of the courts that enforceability of contracts was decided based on their validity. Some important valid and enforceable contracts are explained as under. A. Void and voidable contracts. Basis of difference: void contract, voidable contract. Legal provision section 2, J, ICA section 2, I, ICA. Meaning: a contract which ceases to be enforceable by law becomes void when it ceases to be enforceable. It is a contract which may either be affirmed or rejected at the option of one of the parties to the contract on ground of coercion, undue influence, fraud, or misrepresentation. Nature: it is valid at its inception but later culminates into a void contract. It remains enforceable till it is not declared void by a competent court. Claim for damages: it is allowed only to the extent to restore any benefit received by the party, on the grounds of equity. The injured has the right to initiate action for damages. Validity: any contract when turns void cannot thereafter become valid. A voidable contract may become valid upon lapse of time, affirmation, ratification, waiver of right, acquiescence of the party whose consent was not free. Textbook of Legal Studies XII 2023-2024. www. CBSE Academic. NIC. In. Unit I. Unit 2. UNITIII. Unit IV. UNITV. 58. Unit V. Unit 7. Unit V. B. Contingent and wagering. Basis of difference. Contingent contracts, wagering agreements. Legal provision. Contingent contract is defined under Section 31 of ICA. ICA does not define wagering agreements. Meaning a contingent contract is a contract to do or not to do something depending upon the happening or non-happening of a future uncertain event. Section 30 ICA does not define wagering agreements but declares them to be void. The parties have opposite views regarding an uncertain event and equal chances of gain or loss. There is no other interest of the parties in the agreement except for winning or losing it. Enforceability. A contingent contract is enforceable under the law. A wagering agreement is not enforceable under the law. Uncertain future event. The uncertain future event does not determine the outcome of the contract. It is only collateral to the contract. The uncertain future event decides who wins the wager. Reciprocal promise. There may or may not be reciprocal promise. It is a bet and is thus based on reciprocal promise. Example: for example, a promises to Indian cricket team's jersey if they win the match today. Now, guarantee whether India will win the match. In the same example, a promises to buy B the jersey if he pays him the money, then this will be a promissory condition that depends on the performance of a duty. For example, X enters into a wager with Y. If X's food tech startup gains at least 50,000 customers in 6 months, then Y shall pay X a certain monetary sum, and if it doesn't hit the target, then X shall pay Y the same amount. C. Illegal, unlawful agreements. According to Section 10 ICA, a contract must be made for a lawful consideration and lawful object. If either the consideration or the object is an action or omission prohibited by law, it results into an illegal contract. The agreements entered into for any unlawful or illegal object or consideration cannot be enforced under the law and are thus void. Sec. 24 ICA. However, there is a possibility that the object or the consideration with which the contract was formed initially later turns unlawful or illegal, in which case it becomes void. Lustration. A enters into an agreement with B to share the profits by giving false assurance to the public to get them a job in Singapore. The agreement involves cheating, which is a fraudulent act. The agreement is unlawful and hence it is void. Textbook of Legal Studies XII 2023-2024. www. CBSE Academic. NIC. In 59. Unit I. Unit 2 UNITIII Unit IV. UNITV. Unit V Unit 7 Unit V. Illustration. A agrees to give 1000 rupees to B as penalty if minor daughter is not given to A in marriage. This agreement is opposed to public policy and not enforceable. H. Discharge of contract. Mutual obligations of parties are created in a contract. When the mutual obligations of the parties are fulfilled, the contract comes to an end. When the contract is ended, it is said to be discharged. In other words, discharge means termination of the contractual relations of the parties to the contract. Discharge of a contract may be done by the following ways: discharge by performance, discharge by agreement or consent, discharge by impossibility of performance. Discharge by lapse of time. Discharge by operation of law. Discharge by breach of contract. A. Discharge by performance. When parties to a contract perform their obligations and fulfill their promises, the contract gets discharged by performance. Illustration. An offer to sell his dining set to B for 10,000 rupees. B pays Rs 10,000 to A and A delivers his dining set to B. Here the contract gets discharged by performance as both the parties fulfilled their promises. B. Discharge by agreement or consent. When parties to the contract do not perform their obligations and fulfill their promises in full or in part, as the case may be, the contract gets discharged by novation, rescission, alteration, merger, waiver and remission. I. Novation. A new contract is substituted for an old contract. Illustration. A is indebted to B and B to C. By mutual agreement, B's debt to C and A's debt to B is cancelled and C accepts her as his debtor. This is new contract substituting the old one and hence, novation. E. Rescission. Certain terms or all terms of a contract are cancelled. Illustration. A enters into an agreement with B for buying certain machine parts for their project. Before the agreement ends, A and B change certain terms of the agreement and include those terms in the agreement. E. Remission. Acceptance is made to a promise but not on the complete terms. Illustration. A owes B 5,000 rupees. A pays to B and B accepts 2,000 rupees, in full satisfaction to the whole debt. The old debt is discharged but to a lesser fulfillment of the promise. IV. Merger. Certain terms of a contract or all the terms of a contract are merged into another contract with the consent of the parties. Textbook of Legal Studies XII 2023-2024. www. CBSE Academic. NIC. In. Unit I. Unit 2. UNITIII. Unit IV. UNITV. 60. Unit V. Unit 7. Unit V. Illustration. A enters into a contract with B for the supply of 50 bags of wheat on a specified date. Later it was realized by A that he needs 10 bags of mixed pulses also at the same time. A and B merge the two contracts to supply 50 bags of wheat and 10 bags of mixed pulses on the same date and at the same place. C. Discharge by impossibility of performance. Performance of a contract can become impossible with or without the knowledge of the parties to the contract. A contract may later become unenforceable under the law due to impossibility of performance. It can become impossible to perform the contract subsequently after the parties have entered into the contract. This is known as supervening impossibility, Section 56 ICA. Supervening impossibility takes place by the following: destruction of the subject matter, death or incapacity, non-existence of state of things having an effect directly or indirectly on the contract, outbreak of war, change or amendments in law. Illustration. X agreed to sell his car to Y for Rs 1 lakh and deliver it after 2 months. After a week, X met with an accident and car got completely destroyed. The contract gets discharged by impossibility of performance as the car was completely destroyed. D. Discharge by lapse of time. Time is very significant while entering into a contract. If the contract is not performed within the specified time and the other party does not resort to any action within the limitation period, then he is deprived of his remedy and the contract gets discharged by lapse of time. A. Discharge by operation of law. The following are instances where a contract gets discharged by operation of law: death of either of the parties, insolvency, merger, unauthorized alteration of the terms of the agreement. F. Discharge by breach of contract. Breach means failure to perform the obligation by a party. When a party to a contract does not perform his part of the obligation due to which the contract becomes broken, the person who suffers because of the breach is entitled to receive compensation or damages from the party who has breached the contract. Section 73. Illustration. A agrees to supply 20 liters of oil to B on the 1st of June 2014. On the 1st of June 2014, A does not supply the oil. Then A has breached the contract. Suppose A has supplied the oil but B does not accept the oil, then B has breached the contract. In the first instance, B is entitled to receive compensation from A. In the latter instance, A is entitled to receive compensation from B. Textbook of Legal Studies XII 2023-2024. www. CBSE Academic. NIC. In 61. Unit I. Unit 2 UNITIII Unit IV. UNITV. Unit V Unit 7 Unit V. I. Remedies. In case of breach, a remedy implies a relief given by law to ensure the enforcement of contractual rights or to provide sufficient compensation for the non-performance. In the matters of breach of contract, the remedies available are damages. Specific performance damages are the most common remedy available to the injured party. It entitles them to recover the money compensation for the losses suffered due to the breach. In India, it is covered in Section 73 ICA. The purpose of a contract is to enforce the rights of parties. In event of breach, the promisee can request the performance of specific obligations. Illustration. A agrees to deliver 40 bags of rice to B for Rs. 20,000 on the 15th of July 2022. On the 15th of July 2022, A delivers only 20 bags of rice to B. B is entitled for damages from A for the loss that he suffered because of A non-delivery of 20 bags of rice. Illustration. A contracts to repair B's house in a certain manner, and receives payment in advance. A repairs the house but not according to the contract. B is entitled to recover from A the cost of making the repairs conform to the contract. Exercise. Based on your understanding, answer the following questions. 1. Ramesh sells his bike to his friend Suresh for a consideration of Rs. 50,000, whereas the market price of the said bike is Rs. 65,000. Examine if the agreement is enforceable under law of Contract. 2. D. A minor borrowed a sum of money from M by executing a mortgage of his property in favor of M. Subsequently, D sued for cancellation of mortgage. Is the contract of mortgage valid? Can M recover the sum advanced to D? 3. Apex Chemicals entered into an agreement with Moonled Pharma Limited to supply them with 16 units calcium and 8 units of magnesium powder for its medicine unit. By the time Apex Chemicals supplied 12 units of calcium and 4 units of magnesium, the government restricted free sale of chemicals for life-saving drugs. Every dealer was supposed to get his supply sanctioned from the government to a maximum of 10 units of each chemical. Apex Chemicals found it difficult to complete the order of Moonled Pharma Limited. Moonled Pharma Limited brings a suit for breach of contract against Adarsh Chemicals. Will it succeed? Analyze by referring to relevant provisions. 4. X enters into a contract with Y to pay him 10,000 rupees if the books are delivered to him by Friday. This is an example of contingent contract. Explain why. Bibliography 1. Dr. R. K. Banja, Contract I, Edition 2019-202. www. Legal Service India. Com3. Web links 4. Blog. IP Leaders. In Textbook of Legal Studies XII 2023-2024. www. CBSE Academic. NIC. In Unit I, Unit 2, UNITIII, Unit IV, UNITV, 62, Unit V, Unit 7, Unit V. Law of torts. Learning outcomes. Students will be able to understand the meaning of torts, differentiate between civil and criminal laws, differentiate between tort and breach of contract, identify the sources of tort law, explain the different types of wrongful acts in torts, list the types of intentional torts, explain the components of the tort of negligence, understand the concept of strict liability and its components, differentiate between strict liability and absolute liability. Summarize the different types of harm in torts. A. Introduction. Concept. Tort essentially means a wrong. It is derived from the Latin word tortum, which means twisted or crooked. In law, tort is defined as a civil wrong or a wrongful act of one, either intentional or accidental, that results in injury or harm to another who in turn has recourse to civil remedies for damages or a court order or injunction. According to Sir John Salmond, an English legal scholar, tort is a civil wrong for which the remedy is a common law action for unliquidated damages, and which is not exclusively a breach of contract, or a breach of trust, or other merely equitable obligation. In the words of M.C. Setalwad, the first Attorney General of India, law of torts is an instrument for making people adhere to standards of reasonable behavior and respect the rights and interests of one another. Damages under law of torts are essentially compensatory and seek to place the defendant in the position that he would have been had the wrongful act not been performed. The remedy is often in the nature of unliquidated damages. Unliquidated damages can be defined as the sum of money that cannot be foreseen or assessed by a fixed or pre-decided formula. Damages may be categorized as unliquidated when the amount of damages is unidentifiable or subject to an unforeseen event that makes the amount not calculable. Chapter 3, B. Textbook of Legal Studies XII 2023-2024. www. CBSE Academic. NIC. In 63. Unit I. Unit 2 UNITIII Unit IV. UNITV. Unit V Unit 7 Unit V. It must be mentioned that tort is a civil wrong as distinguished from criminal wrong. Both the substantive elements and the procedures are different in civil law and criminal law. In a criminal case, the state initiates legal proceedings in a criminal court on behalf of the victim and is punished if found guilty by the court. A civil action, like the tort suit, is pursued in a civil court where the person aggrieved or his representatives or survivors prosecute the wrongdoer, usually for compensation in the form of monetary damages and also at times for other relief or injunction. Generally, tort cases aim at compensating the victim while criminal lawsuits often result in punishments, for example, prison sentences. Injunctions are court orders that, for example, may prohibit the wrongdoer from harming the victim or prevent the former from trespassing the latter's property. Occasionally, courts may also grant punitive damages, which are costs or damages in excess of the compensation. It is also important to mark the distinctions between tort and breach of contract. Tort breach of contract. A tort is a civil wrong in which the remedy is action for damages. Breach of contract is a breach of a promise, the primary remedy of which is performance of the contract. Damages are always unliquidated. In breach of contract, the damages are liquidated. In tort, motive may be taken into consideration. In breach of contract, the motive is irrelevant. In tort, duty is bound towards the persons generally. In breach of contract, the duty is bound towards a specific person or persons. In tort, the damages may be compensatory or even exemplary damages may also be awarded. In breach of contract, nature of damages is compensatory. A tort can be intentional or accidental. It includes wrongful acts such as battery and assault, physical or mental injury to the claimant, nuisance, an act which is harmful or offensive to the public or an individual, defamation, where claimant's reputation is injured, property damage, trespass, to claimant's land or property, negligence, careless behavior, and others. Some of these are discussed below. The three fundamental elements of a tort are: 1. Wrongful act. 2. Damage. 3. Remedy. These tortious wrongs may also have aspects which overlap with other fields of law like criminal law and contract law, examples of which may be found in the chapters on criminal law and contract law. In this chapter, we are concerned only with some of the basic features of law of torts in relation to these wrongs. Sources of law of torts. Tort is mostly a common law subject. The law of torts did not develop from a statute or an act passed by the Parliament, but from centuries of judicial decisions, based on case decisions in English courts as well as in courts of other countries following the common law system such as that of India, Canada, Australia or the United States of America. In India as well as in other jurisdictions, both criminal law and contract law are based on statutes, for example, the Indian Penal Code and the Indian Contract Act respectively. However, there is no single statute or a group of statutes that comprehensively deal with tort law as a separate area of law. Textbook of Legal Studies XII 2023-2024. www. CBSE Academic. NIC. In. Unit I. Unit 2. UNITIII. Unit IV. UNITV. 64. Unit V. Unit 7. Unit V. It is easy to explain this difference. A lawyer focusing on contract matters would ordinarily look at the Contract Act or the Sale of Goods Act to find out the rules which might apply to a given fact situation. On the other hand, a tort lawyer cannot merely look at the statute to find out the law that could apply to a given fact situation. A tort lawyer has to pore through the case law including the applicable precedents in other jurisdictions to examine the existence of a tortious wrong. To summarize, the law of torts includes both statutes and case laws and cannot be traced to a single source. However, in many jurisdictions, including in India, there is a move to enact statutes concerning tortious wrongs which were hitherto governed only by case laws. In India, for instance, automobile accidents as well as harm caused to consumers of goods and services are covered by the Motor Vehicle Act of 1988, as amended, and the Consumer Protection Act of 1986, as amended, respectively. B. Kinds of wrongful acts in tort cases. The victim or the plaintiff claims that the defendant or the wrongdoer has conducted a wrongful act or is liable for injury incurred by the plaintiff. Primarily, there are three kinds of wrongs in tort law. The wrongful act can occur: 1. Either intentionally, or 2. negligently on part of the wrongdoer, or 3. the defendant is strictly liable for the wrongful act. B. 1. Intentional tort. An intentional tort requires the claimant to show that the defendant caused the injury on purpose. The claimant must also show that he or she suffered a particular consequence or injury, and that the defendant's actions caused the consequence or injury. Different intentional torts deal in different consequences and intents. Depending on the contexts and situations, there are various kinds of intentional torts. These include assault, battery, false imprisonment, unlawful harassment, invasion of privacy, and so on. These may also have aspects of criminal law, but treating them also as torts increases the possibility of higher compensation. The kinds of intentional torts are explained below. Battery and assault. The tort of battery occurs when the defendant shows an intentional and direct application of physical force of the claimant with the intent to cause harm or offense. Both intent and causation are required for the tort of battery to occur. The act of touching doesn't necessarily have to be done with the defendant's hands always. It could be anything touching the plaintiff, such as throwing hot water at someone. The tort of assault occurs when the defendant intends to cause in the claimant's mind a reasonable apprehension, feeling of anxiety or fear, of an imminent harmful or offensive touching to the claimant. And when this causes the claimant to suffer a reasonable apprehension of an imminent harm. For example, if the defendant throws an iron ball at the claimant and misses his head as the claimant moves his head away from the direction of the iron ball, this amounts to assault. The perception of the claimant is important. If the defendant points an unloaded gun at the claimant who does not know that it is unloaded and he thinks he is about to get shot, this amounts to assault, which can take place without battery. Likewise, battery can take place without assault. For example, someone may hit another person from behind. Textbook of Legal Studies XII 2023-2024. www. CBSE Academic. NIC. In 65. Unit I. Unit 2 UNITIII Unit IV. UNITV. Unit V Unit 7 Unit V. False imprisonment. The intentional tort of false imprisonment is satisfied whenever there is an intent to unlawfully confine or restrain the claimant in a bounded area and when this actually causes the claimant to be knowingly confined or restrained in a bounded area unlawfully. This leads to the total restraint of liberty of a person. For example, the defendant intentionally locks the claimant in the classroom without having the legal authority to do so, and the claimant knows he is trapped. Sometimes courts allow the actual harm to substitute for the awareness of the imprisonment, so even if the claimant is unaware that he is trapped but suffers injury, the tort of false imprisonment is satisfied. However, the claimant should not be trapped willingly and consensually. Trespass to land. The tort of trespass to land occurs when the defendant has the intent to interfere with the possession of land belonging to the claimant. This is done by physically invading property of the claimant without the claimant's approval or consent. The invasion can happen with objects or by people. It includes invasion of some area of air above the land and some area below the land. For example, the defendant may litter the claimant's land, or may create a drainage outlet below the land of the claimant. Trespass to chattels. The tort of trespass to chattel occurs when the defendant has the intent to and does interfere with the lawful possession of goods belonging to the claimant. This is done when the defendant uses or intermeddles with a chattel, movable personal property, which was in the possession of the claimant and causes significant or perpetual dispossession, deprivation of use, or damage as to condition, quality, or value of the chattel, or causes some other harm to claimant's legally secured interest. For example, if the defendant paints the car of claimant that was parked on the side of the street, without the consent of the claimant while the claimant was away, this amounts to trespass to chattels. Conversion. The tort of conversion is somewhat related with the tort of trespass to chattels. Conversion is defined as an act of willful interference, without lawful justification, with any chattel in a manner inconsistent with the right of another, whereby that other is deprived of the use and possession of it. It occurs when the defendant intentionally uses or intermeddles with the chattel of the claimant in such a serious way that it becomes fair to ask for compensation or money payment for the total prior value of the chattel. In other words, the defendant is forced to buy the chattel for a purchase price based on the original value. Thus, the remedy in conversion is forced sale. Conversion is applicable in many situations, including where the chattel is taken, transferred to someone else, changed, misused, or damaged. Unlawful harassment and intentional infliction of emotional distress. Defendant may be held liable for any act of deliberate physical harm to the victim even when no battery or assault is involved. For example, if the defendant lies to the claimant that the latter's son met with a road accident, which causes nervous shock to the claimant resulting in illness, this constitutes tort of unlawful harassment. Sexual harassment may also amount to tort of unlawful harassment. For example, if one follows another person, sends unwanted messages or phone calls. Although there is no violence or threat of violence involved, this act amounts to a tort of harassment. Textbook of Legal Studies XII 2023-2024. www. CBSE Academic. NIC. In. Unit I. Unit 2. UNITIII. Unit IV. UNITV. 66. Unit V. Unit 7. Unit V. Defamation. Defamation is defined as the publication of a statement which tends to lower a person in the estimation of the right-thinking members of society generally, and tends to make them shun or avoid that person. It can be defined as any intentional false communication, either written or spoken, that harms a person's reputation, decreases the respect, regard, or confidence in which a person is held, or induces disparaging, hostile, or disagreeable opinions or feelings against a person. It is interesting to note that defamation can be both a tort as well as a crime. Criminal defamation, the act of offending or defaming a person by committing a crime or offense. For criminal defamation, the liable person can be prosecuted. It is studied in IPC as a criminal act. Civil defamation. Civil defamation involves no criminal offense, but the claimant can sue the wrongdoer for compensation. It is studied under law of torts as a civil wrong. English law divides actions for defamation into libel and slander. Libel refers to causing defamation in a permanent form, i.e., writing or pictures. It is recognized as an offense under the English criminal law. On the other hand, slander refers to causing defamation in a transient form such as spoken words or gestures. Slander is actionable under law of torts in the English law. B. 2. Negligence. Negligence is defined as the breach of the duty to take care which results in damages. Basically, it can be said that the wrongdoer or the defendant has been careless in a way that harms the interest of the victim or the claimant. For example, when the defendant carries out an act of constructing something on her premises, she owes a duty of care towards the claimant, and anyone in proximity, and the standard of duty of care depends on whether the claimant was on the site or in the neighborhood as well as whether the claimant was a lawful visitor or a trespasser. Generally, in order to argue successfully that the defendant has been negligent, the victim or the claimant must establish three elements against the defendant in a tort of negligence case. 1. The defendant owes a duty of care to the victim. 2. There has been a breach of duty of care on part of the defendant. And 3. The breach of the duty to care resulted in the harm suffered by the claimant. Let us consider these elements here. Duty of care. The duty of care principle can be explained by citing an actual case. In Donahue v. Stevenson, a case decided in England, the plaintiff Donahue drank a soft drink, ginger beer, manufactured by the defendant Stevenson. The drink had a decomposed snail in the bottle that made the claimant ill. The court held that the manufacturer owed duty of care to those who are reasonably foreseeable to be affected by the product. In a case like the present, where the goods of the defenders are widely distributed throughout Scotland, it would seem little short of outrageous to make them responsible to members of the public for the condition of the contents of every bottle which issues from their works. It is obvious that, if such responsibility attached to the defenders, they might be called on to meet claims of damages which they could not possibly investigate or answer. Textbook of Legal Studies XII 2023-2024. www. CBSE Academic. NIC. In 67. Unit I. Unit 2 UNITIII Unit IV. UNITV. Unit V Unit 7 Unit V. Thus, the duty of care is owed to those whom one can reasonably foresee as being potentially harmed. This principle is applicable to numerous fact situations. To give another example, a landlord owes a duty of care with reasonable foresight to his tenants and should ensure that no hazardous substance like petrol is stored by him in the basement of the apartment where tenants stay. Breach of duty of care. Once the duty of care is proven, the claimant then must establish that the duty of care was broken. I.e., the defendant was unsuccessful in fulfilling the duty of care in accordance with the standard of reasonableness. The standard is that of reasonable conduct, or reasonable foresight. However, the act need not be flawless. In the case of Donahue v. Stevenson discussed above, the court held that the manufacturers of products owe a duty of reasonable care to the consumers who use the products. Similarly, the standard of duty of reasonable care will vary based on the peculiar fact situation of every case. Harm to the claimant. In the case of Donahue v. Stevenson, the negligence on part of the manufacturer of the soft drink resulted in the illness or injury to the claimant. Or, in the second example, the apartment catches fire because of petrol being stored in the basement causing damage to the tenants. In McPherson v. Buick Motor Company, 1914, a famous American case, the plaintiff bought a car from a retail dealer and was injured when a defective wheel collapsed. The plaintiff sued the defendant, Buick Motor Company. Defendant, the original manufacturer of the car, for negligence. The wheel was not made by the defendant. It was bought from another manufacturer. The defendant, however, failed to inspect the wheel. It was observed by the court that the defendant was responsible for the finished product. It was not at liberty to put the finished product on the market without subjecting the components to tests. In order to establish duty of care in relation to ultimate purchases, it must be proved that a. Nature of the product must be such that it is likely to place life and limb in danger if negligently made. This knowledge of danger must be probable, not merely possible. B. There must be knowledge that in the usual course of events, the danger will be shared by people other than the buyer. This may be inferred from the nature of the transaction and the proximity or remoteness of the relation. The court held that the manufacturer of the product placed this product on the market to be used without inspection by its customers. If the manufacturer was negligent and the danger could be foreseen, a liability will follow. What is no-fault liability? In fault-based liability, the legal right of the claimant is violated due to a mistake of the defendant, and the defendant is liable to pay compensation. However, there are certain situations where the defendant is liable to pay compensation even if the violation of the claimant's right is not done by the defendant, but there is a violation of the claimant's right. This is known as no-fault liability. In short, liability arising without any fault is a no-fault liability. It covers two kinds of liability: strict liability, absolute liability. Strict liability. Strict liability is a standard of liability under which a person is legally responsible for the consequences. Textbook of Legal Studies XII 2023-2024. www. CBSE Academic. NIC. In. Unit I. Unit 2. UNITIII. Unit IV. UNITV. 68. Unit V Unit 7 Unit V. Of an activity even in the absence of fault or criminal intent from the defendant. Under the strict liability law, if the defendant possesses anything that is inherently dangerous, as specified under the ultra-hazardous definition, the defendant is then strictly liable for any damages caused by such possession, no matter how careful the defendant is in safeguarding them. The claimant does not have to establish any sort of or level of blame attributable to the defendant based on the intention or the degree of carelessness. The rule of strict liability evolved in the year 1868, in the case of Rylands vs. Fletcher, which took place in England. Rylands and Fletcher were neighbors. Rylands owned a mill for whose energy requirement he constructed a water reservoir on his land. The work of construction was done by an independent contractor who was negligent in his work. Due to this negligence, the water escaped and leaked into Fletcher's mines, causing heavy losses to him. Fletcher sued Rylands for the damage caused. Rylands took the defense that the construction work was carried out by an agency and was inspected by an engineer. It was contended that Rylands was not a part of the work and was also not informed about the security regarding the construction. The court held that it does not matter what care the appellant took, but he was responsible for the damage as he brought such an article to his premises which could be dangerous if it escapes. Rylands was thus held liable for the loss incurred by Fletcher and had to pay compensation. In the above case, three basic principles regarding strict liability were established. 1. Dangerous thing, non-natural use of the land. 2. Escape, the escape of water from Rylands' land. 3. Liability as the thing escaped, it caused damage. If someone brings on his land something that is dangerous and it escapes, and because of this escape damage is caused, the person is strictly liable. The general rule with respect to ultra-hazardous activity is that when the defendant carries out or keeps an unusually hazardous situation or activity on his or her building or involves in an activity that offers an inevitable danger of injury to the claimant or his or her property, the defendant could be responsible for the damage caused even if the defendant has exercised reasonable care to prevent the harm. Exceptions to strict liability. 1. Plaintiff's own fault. When the cause of the damage is an act or default of the claimant himself, no remedy would be available to the plaintiff in that case. 2. Act of God. When the escape is caused directly by natural causes without any human intervention, then the defendant can use act of God as a defense. 3. Mutual benefit. When there is express or implied consent of the plaintiff to the presence of the source of damage or danger. Also, there is no negligence on the part of the defendant. In such a case, the defendant will not be held liable. 4. Act of stranger. When the cause of harm is the act of a stranger or third party. Here, it should be noted that this third party is neither the servant of the defendant nor he is having any control over that person. 5. Statutory act. If it is an act of the government or corporation, then it is also a defense. Textbook of Legal Studies XII 2023-2024. www. CBSE Academic. NIC. In 69. Unit I. Unit 2 UNITIII Unit IV. UNITV. Unit V Unit 7 Unit V. Absolute liability. In India, a related principle of absolute liability was introduced by the Supreme Court in the aftermath of the two instances of gas leaks from factories killing thousands and injuring lakhs. The first case was the infamous Bhopal gas leak disaster of 1984, where a factory of the Union Carbide Corporation located in Bhopal had a major leakage of the gas methyl isocyanate that killed 2,260 and injured around 600,000 people. In the second incident of 1985 in Delhi, a factory of the Shri Ram Foods and Fertilizer Industries leaked oleum gas that killed one person that had few others hospitalized and created huge panic among the residents. The then Chief Justice of India P. N. Bhagwati, in the famous 1987 case of M.C. Mehta v. Shri Ram Foods and Fertilizer Industries, held. We are of the view that an enterprise, which is engaged in a hazardous or inherently dangerous industry, which poses a potential threat to the health and safety of the persons working in the factory and residing in the surrounding areas, owes an absolute and non-delegable duty to the community to ensure that no harm results to anyone on account of hazardous or inherently dangerous activity in which it is engaged must be conducted with the highest standards of safety, and if any harm is done on account of such activity, the enterprise must be absolutely liable to compensate for such harm, and it should be no answer to the enterprise to say that it had taken all reasonable care and that the harm occurred without any negligence on its part. If an enterprise is engaged in some inherently dangerous activity from which it is deriving commercial gain and that activity is capable of causing catastrophic damage, then the industry officials are absolutely liable to pay compensation to the aggrieved parties. The industry cannot plead that all safety measures were taken care of by them and that there was no negligence on their part. They will not be allowed any exceptions, neither can they take up any defense like that of act of God or act of stranger. The basic principles of absolute liability as emerged above are: 1. Enterprise, commercial objective. 2. Hazardous or inherently dangerous activity. 3. Escape is not necessary. Differences between strict liability and absolute liability. 1. Strict liability arises in cases in which the court holds the defendant liable to pay compensation for the loss incurred by the claimant, even if such losses are neither intentionally nor negligently suffered. However, when there is an injury caused to a workman in the course of employment, the court holds the employer responsible for providing compensation. Here it is immaterial who caused the injury. In most cases, the employer has to pay the liability. This is called absolute liability. 2. Strict liability is applicable to persons, whereas absolute liability is applicable to enterprises, i.e., commercial undertakings. 3. In strict liability, the escape of hazardous or dangerous components from the premises of the owner is necessary. But escape is not necessary in absolute liability. 4. In the case of strict liability, the defendant has got certain exceptions that she can use to prevent himself from the liability. But no exceptions are provided in the case of absolute liability to the defendant. This means that, if any person faces damages due to the hazardous element, then the defendant would be absolutely liable for the same. Textbook of Legal Studies XII 2023-2024. www. CBSE Academic. NIC. In. Unit I. Unit 2. UNITIII. Unit IV. UNITV. 70. Unit V. Unit 7. Unit V. 5. The compensation is as per the nature and quantum of damages incurred in case of strict liability. In absolute liability, the quantum of damages relies on the magnitude and financial capability of the organization. Basis for comparison: strict liability, absolute liability. Meaning: strict liability implies the legal responsibility of a person for compensating the injured or aggrieved, even when he or she was not at fault or negligent. Absolute liability arises from inherently hazardous activities like keeping dangerous animals or using explosives. Talks about person, enterprise. Escape necessary, not necessary. Exceptions: yes, number. Payment of compensation: nature and quantum of damages exemplary in nature. C. Summary of the kinds of harms. Here is the summary of the examples of the many ways in which the claimant may suffer injuries that have been discussed in this chapter. A. Property interests in land. The law of tort protects the claimant's interests in her landed property by preventing intentional intrusions or trespass of the property by the defendant or the wrongdoer. The claimant may also suffer harm by the damage caused due to carelessness or negligence of the defendant. When the defendant interferes with the claimant's right to enjoy his/her land, the defendant commits the tort of nuisance. B. Other types of property tort. Law prohibits taking away of tangible property deliberately, which amounts to the tort of conversion. The damage to the property may also occur due to carelessness or negligence. C. Bodily injury tort law protects the claimant against any harm to his/her interests of bodily integrity. Tort of battery and assault applies to any intentional harm caused to the body. Harm may also be caused by negligence as well as any breach of statutory duty like traffic laws, health laws, and so on. Mental distress is an element in bodily injury which raises any compensation to the victim. D. Economic interests to a lesser extent. The economic interests are also protected by the law of tort. Injury caused by both intentional act as well as negligence can cause economic harm to the claimant. Conclusion. To conclude, it can be said that unlike a crime, law of torts does not aim to punish the wrongdoer. Rather, it aims to help the aggrieved person reach the position he/she was in before the cause of action arose. It thus seeks to provide restorative justice. Textbook of Legal Studies XII 2023-2024. www. CBSE Academic. NIC. In 71. Unit I. Unit 2 UNITIII Unit IV. UNITV. Unit V Unit 7 Unit V. Exercise. Based on your understanding, answer the following questions. 1. Define what is law of tort. What is the difference between tort law and criminal law? 2. What are the sources of tort law? 3. What is intentional tort? Explain at least 3 different kinds of intentional tort. 4. What is tort of negligence and how does duty of care relate with negligence? 5. What is strict liability principle? Give one example. 6. Some basic principles regarding strict liability were established in Ryland v. Fletcher. Discuss these principles. 7. There are certain exceptions to strict liability which are not available in a case of absolute liability. List these exceptions. 8. Discuss the main differences between strict liability and absolute liability, with the help of relevant case law. 9. What are the objectives behind having tort law? 10. Explain the meaning of the following terms. A. Unliquidated damages. B. Defamation. C. Conversion. Textbook of Legal Studies XII 2023-2024. www. CBSE Academic. NIC. In. Unit I. Unit 2. UNITIII. Unit IV. UNITV. 72. Unit V Unit 7 Unit V. Property law. Learning outcomes. Students will be able to understand the meaning of the term property and transfer of property, understand the types of property under the Transfer of Property Act 1882 and Sale of Goods Act 1932. Distinguish between the types of property and its transfer, describe the doctrine of election and doctrine of lis pendens, elaborate the process of transfer of property, explain the different modes in which an immovable property can be transferred. I. Introduction. Before the advent of the British Kingdom, each community in India was governed by its respective customary law in matters relating to transfer of property. With the establishment of the formal litigation system and in absence of any legislation in this area, to begin with, the English judges applied the common law of England and the rules of equity, justice and good conscience with respect to disputes relating to transfer of property. The unsuitability of these provisions to the Indian conditions. The resulting conflict and the need for clarity of rules relating to this important branch of law necessitated the enactment of legislation. Drafted in 1870, the Transfer of Property Act saw the light of the day in 1882 and provided the basic principles for transfer of both movable and immovable properties. Based primarily on the English law of real property, it attempted to mold these principles to suit the Indian conditions. Moreover, a separate enactment titled the Sale of Goods Act, 1930 feet was passed to deal with transfer of movable property by sale. The Transfer of Property Act, 1882 contains the general principles of transfer of property and detailed rules with respect to specific transfer of a movable property by sale, exchange, mortgage, lease and gift. 2. Types of property. The word property has not been defined in the Act, but it has a very wide meaning and includes properties of all descriptions. It includes movable properties such as cases, books, etc. And includes immovable properties also such as lands or houses. It also includes intangible properties such as ownership, tenancy, copyrights, etc. As per Section 3, the immovable property does not include standing timber, growing crop and grass. Standing timbers. Standing timbers are trees fit for use for building or repairing houses. The word standing timber includes babul tree, shisham, peepal, banyan, teak, bamboo, etc. The fruit-bearing trees like mango, jackfruit, jamun, etc. are not standing timber, and they are immovable properties. Fatima Bibi vs. Arfana Begum, Air 1980 all 394. Chapter 3, C. Textbook of Legal Studies XII 20232024. www. CBSE Academic. NIC. In 73. Unit I. Unit 2 UNITIII Unit IV. UNITV. Unit V Unit 7 Unit V. Growing crop. It includes all vegetable growths which have no existence apart from their produce such as pan leaf, sugarcane etc. Grass. Grass is a movable property, but if it is right to cut grass it would be an interest in land and hence forms a movable property. Whether trees can be regarded as movable or immovable depends upon the circumstances of the case. If the intention is that trees should continue to have the benefit of further sustenance or nutriment by the soil, land, e.g., enjoining their fruits, then such tree is a movable property. Property. But if the intention is to cut them down sooner or later for the purpose utilizing the wood for building or other industrial purposes, they would be timber and accordingly be regarded as movable property. Shantabai v. State of Bombay, Air 1958 SC 532, as per Section 3, 25, General Clauses Act, 1897. A movable property shall include land, benefits to arise out of land and things attached to the earth, or permanently fastened to anything attached to the earth. In the case of Sukri Kurdepa vs. Gundakul, 1872, Court has explained that movability may be defined to be a capacity in a thing of suffering alteration. On the other hand, if a thing cannot change its place without injury to the quality, it is immovable. In Marshall v. Green, 33 LT 404, there was a sale of trees where they were cut and taken away. The court held that the sale was not that of a movable property. Section 2, C, of the Benami Transactions Prohibition Act, 1988 defines property as property, means property of any kind, whether movable or immovable, tangible or intangible, and includes any right or interest in such property. Section 2, 11, of the Sale of Good Act, 1930 defines property as property, means the general property in goods, and not merely a special property. Basis movable property, immovable property. A. Movement of property. The movable property can easily be transported from one place to another, without changing its shape, capacity, quantity, or quality. The immovable property cannot easily be transported from one place to another. B. Transfer mere delivery with intention to transfer the movable property completes the transfer. Mere delivery does not sufficient for a valid transfer. The property must be registered in the name of the transferee. C. Registration of movable Property is optional under the Registration Act 1908. Registration of a movable property is compulsory, mandatory under the Registration Act 1908, subject to the condition that its value exceeds Rs. 100. D. Legal provision transfer of movable property is regulated by Sales of Goods Act 1932. Transfer of a movable property is regulated by Transfer of Property Act 1882, Textbook of Legal Studies 12-2023-2024. www. CBC Academic. NIC. In. Unit I. Unit 2. UNITIII. Unit IV. Unit V. 74. Unit V. Unit 7. Unit 8. 3. Transfer. Transfer of property is an act of conveying property from one person to another, in the present or future. Matters relating to the property are governed by the Transfer of Property Act, 1882 in India. The object of the Transfer of Property Act is to regulate the transfer of property between living persons. It shall also serve as the code of contract law governing a movable property. The Transfer of Property Act, 1882 provides clarity on the subject. It is a systematic and uniform law on the transfer of a movable property in India. The transfer of property may also take place by inheritance and succession. The laws relating to such transfer are governed by the respective religious laws or practices, as the case may be. Who can transfer property? Any person who is competent to contract, person above 18 years of age, having a sound mind and not disqualified by any law in force, and authorized to dispose of property viz. Owner of the property or any person authorized to sell the property, can make a transfer. The person who transfers the property is called the transferor and the person to whom the transfer is made is called the transferee. According to Section 8 of the Transfer of Property Act 1882, the Act, by transferring property, the transferor transfers all rights in a property. Essentials of a valid transfer. With regard to the law of property, a transfer is a process of conveying the rights and liabilities with respect to a property by one person to another. It is therefore with the formation of an agreement culminating into a contract that the transfer of property takes place. Transfer may be by agreement between parties, i.e., by contract explained in upcoming chapter of contracts, transfer by will or succession. Here in this chapter we are dealing with transfer by agreement between parties. The following are the essentials for a valid transfer of property. In a transfer of property, the transfer should be between two or more living persons. The property that is going to be transferred should be free from encumbrances, hindrances of any form, and be of a transferable nature. The transfer should not be for an unlawful object or an unlawful consideration. For a detailed understanding, refer the chapter on contracts involving a person legally disqualified to be a transferor or transferee. The transferor who transfers the property must be competent to make the transfer, be entitled to the transferable property, be authorized to dispose of the property if the property is not his own property. The transfer shall be made according to the appropriate mode of transfer. Necessary formalities like registration, attestation, etc. should be complied with. In the case of a conditional transfer, where an interest is created on the fulfillment of a condition, the condition should not be illegal, immoral, impossible, or opposed to public policy. Textbook of Legal Studies 12-2023-2024. www. CBC Academic. NIC. In 75. Unit I. Unit 2 UNITIII Unit IV. Unit V. Unit V Unit 7 Unit 8. How can property be transferred? 1. Mode of transfer. The mode of transfer of property varies according to the value of the property. If the value of the property is more than Rs. 100, then transfer has to be made only by a registered instrument. If the property is tangible where the value of the property is less than Rs. 100, then transfer has to be made only by delivery, whereas for intangible property, transfer has to be made only by registered instrument. A registered instrument contains the records of the owner of the property, for example, shares, bonds, etc. 2. Attestation. A registered instrument must be attested at least by 2 witnesses to the transfer. The definition of attestation is given in Section 3 of the Transfer of Property Act 1882. Attestation means affixing the signature to the instrument for the transfer of property. The witnesses should mark their signature too on the instrument with the intention to attest. The intention behind including this provision was to ensure that transfer was done with the free will of the executant. 3. Registration. Registration of the instrument is an essential legal formality. During registration, the parties to the transfer must be present to affix their signatures to the document and complete the transaction with regard to a movable property. While doing so, the document for transfer must mention clearly the rights, obligations, and liabilities of the parties to the transfer. Registration shall take place by finally affixing a seal of the registrar's office, which shall be subsequently included in the official records. Indian Registration Act is an act to consolidate the enactments relating to the registration of documents. Registration means recording of the contents of the document. Section 17 of the Indian Registration Act 1908 deals with the documents that are compulsory to be registered. 4. Mutation. Once a property has been transferred by way of relinquishment, sale, or gift deed in the name of the recipient, it is also important to have the transfer recorded in the municipal records by way of mutation. 5. Payment of fee. Stamp duty on transfer is payable as per applicable state laws. In Madam Pillai v. Badarkali, 45 Mad 612, Facebook, the plaintiff, being the first wife, made a claim for maintenance to her husband. The husband orally transferred his lands of the value of Rs. 100 to the plaintiff. Later, he executed an instrument of sale in favor of the defendant for the same property. The plaintiff initiated a suit stating that the transfer was initially made in her favor and the subsequent sale to the defendant was not valid. The defendant stated that the transfer in favor of the plaintiff failed for want of a registered instrument. The court held that the plaintiff acquired a title by way of oral transfer and she is entitled to the property though the instrument of sale was not registered. IV. Doctrine of election. According to the principle of doctrine of election, Section 35 of the TPA, if a person to the transfer gets 2 selections, a benefit and a burden, then he has to accept both the benefit and the burden. Textbook of Legal Studies 12-2023-2024. www. CBCacademic. NIC. In. Unit I. Unit 2. UNITIII. Unit IV. Unit V. 76. Unit V. Unit 7. Unit 8. Or none. He cannot accept the benefit and reject the burden in a single transaction. In other words, while claiming advantage of an instrument, the burden of the instrument should also be accepted. Illustration. A sells his garden as well as his house through one instrument to B. Whereas, B wants to retain only the house and wants to cancel the transfer regarding the garden. According to the doctrine of election, B has to retain the garden if he wants to retain the house, or cancel the whole transaction. B cannot retain the house and cancel the transfer regarding the garden. The doctrine of election is based on the principle of equity, that one cannot take what is beneficial to him and disapprove that which is against him under the same instrument. The Latin maxim, quod approbo non reprobo, means that no one can approbate and reprobate. In other words, a person cannot accept a thing and reject another in the same instrument. This maxim is one of the underlying principles of doctrine of election. In simple words, where a person takes some benefit under a deed or instrument, he must also bear its burden. Quod approbo non reprobo, approbate and reprobate means to approve and disapprove. This principle is based on the maxim, quod approbo non reprobo, which translates to, that which I approve, I cannot disapprove. Therefore, an individual has to either accept the whole contract, order etc., or reject the whole thing. The principle of the doctrine of election was explained by the House of Lords in the leading case of Cooper vs. Cooper. In Cooper v. Cooper, Lord Hatha explained the principle underlying the doctrine of election in the following words. There is an obligation on him who takes a benefit under a will or other instrument to give full effect to that instrument under which he takes a benefit. And if it be found that instrument purports to deal with something which it was beyond the power of the donor or settlor to dispose of, but to which effect can be given by the concurrence of him who receives a benefit under the same instrument, the law will impose on him who takes the benefit the obligation of carrying the instrument into full and complete force and effect. Section 35 of the Transfer of Property Act, 1882 embodied the doctrine of election. The court also held that the doctrine of election applied on every instrument and all types of property. Doctrine of lis pendens. Doctrine of lis pendens is embodied in Section 52 of the Transfer of Property Act, 1882. Lis pendens literally means a pending suit. The doctrine states that a property under a pending suit should not be transferred to a third party during a pending suit in such a way it affects the rights of any party concerned with the property. That means, no new interest should be created by way of transfer of a property during the pendency of a suit relating to it. The doctrine of lis pendens emerged from the Latin maxim, ut lite pendent nihil innovator, meaning, nothing new should be introduced in a pending litigation. The objective of the doctrine of lis pendens is to subjugate all parties to a pending litigation of a property, to the authoritative decision of the court. The doctrine reflects the control which a court acquires over property involved in a pending suit until its final judgment. When a suit or litigation is pending on an immovable property, then that immovable property cannot be transferred. To constitute lis pendens, the following conditions should be satisfied. A suit or proceeding involving the immovable property should be pending. The right to the immovable property must be in question in the suit or proceeding. Textbook of Legal Studies 12-2023-2024. www.cbckademic. NIC. In 77. Unit I. Unit 2 UNITIII Unit IV. Unit V. Unit V Unit 7 Unit 8. The property in litigation should be transferred. The transferred property should affect the rights of the other person to the transfer. Illustration. A has litigation in determining the title of the property with X. During the period of litigation, A initiates a sale of the property in favor of B. According to the doctrine of lis pendens, the property cannot be sold because the property is involved in litigation. The Supreme Court, SC, in Dev Raj Dogra and others v. Gyan Chand Jan and others interpreted the meaning of the Section 52 of the TP Act and laid down the preconditions as follows. 1. A suit or a proceeding in which any right to a movable property must be directly and specifically in question, must be pending. 2. The suit or the proceeding shall not be a collusive one. 3. Such property during the pendency of such a suit or proceeding cannot be transferred or otherwise dealt with by any party to the suit or proceeding so as to affect the right of any other party thereto under any decree or order which may be passed therein except under the authority of court. In other words, any transfer of such property or any dealing with such property during the pendency of the suit is prohibited except under the authority of court, if such transfer or otherwise dealing with the property by any party to the suit or proceeding affects the right of any other party to the suit or proceeding under any order or decree which may be passed in the said suit or proceeding. Source: India Qanun. The SC observed that Section 52 of the Act does not declare a pendent light transfer by a party to the suit is void or illegal, but only makes the pendent light purchaser bound by the decision of the pending litigation. Hardev Singh v. Gurmail Singh. Thus, if during the pendency of any suit in a court of competent jurisdiction, in which any right of an immovable property is in question, such immovable property cannot be transferred by any party to the suit so as to affect the rights of any other party to the suit under any decree that may be made in such a suit. Mode of transfer. 1. Sale. Sale means a transfer of ownership, right to possess something, of the property in exchange for a price, money, Section 54 of the TPA. Seller is the person who transfers the property and buyer is the person to whom the property is transferred. The consideration in a sale is usually money. For a detailed understanding, refer the chapter on contracts. Illustration. A sells his house for Rs. 2 lakhs to B. This is called sale. Here, A is the seller and B is the buyer. Rs. 2 lakhs is the consideration, which is money. The following are the essentials for a sale to be valid. There should be two different parties, the seller and the buyer. Both the parties should be competent to transfer. The property to be transferred should be in existence. Consideration for the transfer should be money. The contract should be in accordance with law. Textbook of Legal Studies 12-2023-2024. www. CBCacademic. NIC. In. Unit I. Unit 2. UNITIII. Unit IV. Unit V. 78. Unit V. Unit 7. Unit 8. V. 2. Lease. A lease under the Transfer of Property Act is a contract by which one party transfers the right to enjoy the land, property, services, etc. to another for a specified time, usually in return for a periodic payment. But does not constitute a sale. It is called a lease. Section 105 of the TPA. A lease can be done only of a movable property. A lease is a transfer of the right to enjoy a property for a specific period of time in consideration of a price. The lessor is the person who lets out the property for lease or transferor, and the lessee is the person to whom the property is leased or the transferee in a lease. The lessee can also sublet the lease, and the relation between the lessee and the sub-lessee will be that of the lessor and lessee. A sublease is the renting of property by a tenant to a third party for a portion of the tenant's existing lease contract. Even if a tenant subleases a property, the original tenant is still liable for the obligations stated in the lease agreement, such as the payment of rent each month. Subleasing with the consent of the landlord is legal in India. If the agreement allows the tenant to sublease it, the tenant can sublease a portion of the property to a third party. When a tenant whose name is on the lease rents a room, a portion of the property, or all of the property to another, it is referred to as subleasing, or subletting. The subtenant must pay rent and comply with the lease terms, but the principal tenant remains ultimately responsible for the lease. Illustration. A for a period of 3 years lets out his property for use to B for a sum of Rs. 50,000, this is called a lease. A is the lessor and B is the lessee. If B sublets the property to C, then B will be the lessee and C will be the sublessee. The relation between B and C will be of that relationship that is between A and B. V. 3. Exchange. When two persons transfer ownership of one thing for the ownership of another, it is called exchange, Section 118 of the TPA. Transfer of property by exchange can be made only by way of sale. The rights and liabilities of the parties to exchange shall be that of the rights and liabilities of the buyer to the extent of receiving and that of the seller to the extent of giving. Illustration. A offers to sell his cottage to B. B in consideration of the cottage sells his farm to A. Instead of getting money for his cottage, A has received a farm from B. This is an example for exchange. The rights and liabilities of A will be that of seller towards the sale of the cottage and will be that of buyer towards the sale of the farm. Similarly, the rights and liabilities of B will be that of buyer towards the sale of the cottage and that of seller towards the sale of the farm. V. 4. Gift. A transfer of ownership of property that is made voluntarily and without consideration is called gift, Section 122 of the TPA. The person making the transfer is called the donor and the person to whom it is made is called the donee. If the donee expires before accepting the gift, it becomes void. Illustration. A gives his car to B. B accepts the car. But B does not pay anything in return for the car. This is known as gift. In this case, A is the donor and B is the donee. Textbook of Legal Studies 12-2023-2024. www. CBCacademic. NIC. In 79. Unit I. Unit 2 UNITIII Unit IV. Unit V. Unit V, Unit 7, Unit 8. Sale, lease, exchange and gift. Basis: sale, lease, exchange, gift. Transfer of ownership for price. Transfer of limited ownership for rent. Transfer of ownership for some other property. Transfer of ownership without consideration. Consideration: price, rent another property. No consideration. Mode: sale deed should be registered. Lease deed should be registered. Sale deed should be registered. Gift of a movable property should be registered. Exercise 1. X is an owner of mango groves where exceptional quality of mangoes are produced by hybrid mode. He is one of the largest exporters of mangoes. Till the year 2020, he has been into exporting mangoes. Due to setback to his business because of COVID, from 2021 he shifted to selling mango wood in local markets. Identify if there is any difference in the type of property he has been dealing with in the year 2020 and in 2021 respectively. 2. A has a matter pertaining to the title of a movable property situated at Bangalore would be. The matter is sub judice in the Court of Civil Judge at Bangalore. During the period of pendency of suit, A's mother was to be operated for open heart surgery, and to accommodate the financial need, he sold this property situated at Bangalore to C. Decide the validity of the transfer made by A to C. Explain the requisites of principle of law involved. 3. Manan and Ketan enter into an agreement of lease of property for a tenure of 24 months at a consideration of 9,000 rupees per month. Ketan is expected to return the property at the expiry of this term in the condition in which he received it. Ketan was transferred to another city but for a short span. He sublets the property to Manoj for a sum of 10,000 rupees. Manoj carries OU such alterations as would depreciate the property. Decide if Ketan is authorized to make such transfer by sublease. Also highlight the remedy available to Manan. 4. Elucidate on the importance of attestation as an important step preceding registration. Textbook of Legal Studies 12-2023-2024. www.cbckdemic. NIC. In. Unit I. Unit 2. UNITIII. Unit IV. Unit V. 80. Unit V. Unit 7. Unit 8. Intellectual Property Law. Learning outcomes: students will be able to explain the nature and meaning of intellectual property, explain the meaning of intellectual property rights, explain the importance of international conventions on intellectual property rights, recall the historical perspective of intellectual property, analyze the importance of different types of intellectual property rights and its importance in the commercial world. Appreciate the rights granted to the holder of intellectual property rights. I. Meaning of intellectual property. Intellectual property is an intangible property that comes into existence through human intellect. It refers to the creation of the mind or products of human intellect such as inventions, designs, artistic work, names, symbols, images, etc. 2. Intellectual property rights. The term intellectual property rights, IPR, refers to the bundle of rights conferred by law on a creator, owner of intellectual property. These rights are the rights given to persons over the creations of their minds. They usually give the creator an exclusive right over the use of his, her creation for a certain period of time. They seek to protect the interests of the creators by rewarding their mental labor and allowing them to retain property rights over their creations. The creators, inventors, are thus allowed to benefit from their creations. The main reason for granting these rights is to encourage inventions and creations that promote social, economic, scientific, and cultural development of society. Intellectual property is divided into two categories. Chapter 3, D, Textbook of Legal Studies 12-2023-2024. www.cbckdemic. NIC. In 81. Unit I. Unit 2 UNITIII. Unit IV. Unit V. Unit V. Unit 7. Unit 8. 1. Industrial property. This includes inventions, patents, trademarks, industrial designs, and geographic indications of source. And 2. copyright. This includes literary and artistic works such as novels, poems and plays, films, musical works, artistic works such as drawings, paintings, photographs and sculptures, and architectural designs. 3. What are the international obligations that have shaped Indian IPR? Treaty Year Principles and Objectives. The Paris Convention for the Protection of Industrial Properties. The Paris Convention was adopted on the 20th of March 1883 in Paris and was enforced on the 7th of July 1884. 1. National treatment in the context of legal protection for industrial property. The principle of national treatment requires each member country of the Paris Convention to provide equal legal protection for the inventions of nationals from other member countries, as it would for its own nationals. 2. Framework of priority. The Paris Convention also upholds the principle of priority framework, allowing an inventor to protect their invention simultaneously in various countries. The Berne Convention for the Protection of Literary and Artistic Works. The Berne Convention was adopted on the 9th of September 1886 and came into force on the 4th of December 1887. The Berne Convention was originally signed in 1886 at Bern in Switzerland. 1. National treatment stipulated that any work originating in a contracting state, including works of authors who are nationals of that state or works first published in that state, should receive the same legal protection in every other contracting state as the latter state grants to its own nationals. 2. Automatic protection mandated that legal protection should not be subject to compliance with any formalities. 3. Independence of protection decreed that legal protection should be independent of the existence of protection in the country of origin of the work. The Universal Copyright Convention, UCC. Established in the year 1952. 1. National treatment. The UCC adheres to the principle of national treatment rather than automatic protection, which implies that contracting countries are not obligated to provide foreign works with automatic protection if the national requirements are not met. Textbook of Legal Studies 12-2023-2024. www.cbckademic. NIC. In. Unit I. Unit 2. UNITIII. Unit IV. Unit V. 82. Unit V. Unit 7. Unit 8. 2. The term of the work under the UCC, original literary, artistic, and scientific works are eligible for protection. To provide reasonable notice of the copyright claim, a copyright notice should accompany the work. The UCC stipulates that protection for a work lasts for the duration of the author's lifetime and an additional 25 years following the author's death. 3. Minimum rights. As per the UCC's provisions, the contracting countries must provide a specific set of minimum rights to the lawful owner of the work, provided they do not create any conflict with the spirit of the convention. World Intellectual Property Organization, WIPO. The WIPO Convention, which is the primary instrument of the World Intellectual Property Organization, was signed on July 14, 1967, in Stockholm. It came into effect in 1970 and was subsequently amended in 1979. In 1974, the WIPO became one of the specialized agencies of the United Nations, UN, system. The WIPO had two primary objectives, which were, 1. To promote the legal protection of intellectual property worldwide. 2. To facilitate administrative cooperation between the intellectual property unions created by treaties administered by the WIPO. IV. Brief historical perspective. With the establishment of the World Trade Organization, WTO, the importance and role of intellectual property protection was crystallized in the Trade-Related Intellectual Property Systems, TRIPS, agreement. It was negotiated at the end of the Uruguay round of the General Agreement on Tariffs and Trade, GATT, treaty in 1994. The TRIPS agreement came into effect on the 1st of January 1995 and is the most comprehensive multilateral agreement on intellectual property. It encompasses all forms of intellectual property and aims at harmonizing and strengthening standards of protection and providing effective enforcement of intellectual property rights at both national and international levels. India, being signatory to the TRIPS agreement, has passed several legislations for the protection of intellectual property rights to meet the international obligations. Some of these legislations are listed below. Trademark Act, 1999, Designs Act, 2000, Copyright Act, 1957, as amended, Patents Act, 1970, as amended, Geographical Indications of Goods, Registration and Protection Act, 1999, Protection of Plant Varieties and Farmers' Rights Act, 2001. The history of patent law dates back to 1911. Around this time, the Indian Patents and Designs Act, 1911 was enacted. The present act governing patents law in India, the Patents Act, 1970, came into force in 1972. It amended and consolidated the existing law relating to patents in India. The Act went through an amendment in 2005 to be compliant with the TRIPS agreement and is now known as the Textbook of Legal Studies 12-2023-2024. www. CBC Academic. NIC. In 83. Unit I. Unit 2 UNITIII Unit IV. Unit V. Unit V Unit 7 Unit 8. Patents, Amendments, Act, 2005. Through this amendment, product patent was extended to all fields of technology including food, drugs, chemicals, and microorganisms. V. Copyright. What is copyright? Copyright is a right given by the law to creators of literary, dramatic, musical and artistic works and producers of cinematograph films and sound recordings. It is a bundle of rights including rights of reproduction, communication to the public, adaptation and translation of the work. This protection is automatic upon creation of the work and does not depend on registration. What is the scope of protection in the Copyright Act, 1957? In India, the law relating to copyright is governed by the Copyright Act, 1957. To get the protection of copyright, a work must be original. Mere ideas, knowledge or concepts are not copyrightable. Having said that, copyright protects the original expression of information and ideas. Copyright can be claimed by either the creator or the person who has inherited the rights of ownership from the original creator or an agent who is allowed to act on behalf of the creator. Work. What is a work? All subject matters protected by copyright are called protected works. Section 2(y) of the Act defines work. It includes the following: Textbook of Legal Studies 12-2023-2024. www. CBC Academic. NIC. In. Unit I. Unit 2. UNITIII. Unit IV. Unit V. 84. Unit V Unit 7 Unit 8. When is a work protected by copyright? A work is protected by copyright when 1. It falls within the category of work under the Act. 2. The work must be recorded, fixed in material form, tangible form. And 3. The work must be original. Registration of copyright. Is it necessary to register a work to claim copyright? No. Acquisition of copyright is automatic and it does not require any formality. However, certificate of registration of copyright and the entries made therein serve as prima facie evidence in a court of law with reference to dispute relating to ownership of copyright. What is the procedure for registration of a work under the Copyright Act, 1957? Copyright comes into existence as soon as a work is created and no formality is required to be completed for acquiring copyright. However, facilities exist for having the work registered in the Register of Copyrights. Term of copyright. Is copyright protected in perpetuity? No. It is protected for a limited period of time. What is the term of protection of copyright? The general rule is that copyright lasts for 60 years. In the case of original literary, dramatic, musical and artistic works, the 60-year period is counted from the year following the death of the author. In the case of cinematograph films, sound recordings, photographs, posthumous publications, anonymous and pseudonymous publications, works of government and works of international organizations, the 60-year period is counted from the date of publication. Rights of the owner of a copyright. Economic rights. This allows the rights owner to derive financial reward from the use of their works by others. Within this category are other rights such as 1. Right to reproduce the work. Reproduction is an act of copying from the previously finished works or giving it a differential form by adding, editing, or modifying the same. Such right shall exclusively be exercised by the owner of the work and shall not be infringed by any other person, since the act of reproduction of the work may economically make benefits to its owner. 2. Right to distribute in market. The owner of the copyrighted work also has a right to distribute in the market and make money out of it. The act of distribution may be in the form of sale, lending for free or for a consideration, rental, or free distribution by the way of gift. 3. Right to communication to the public. It means letting or making the product, work available to the public by way of broadcasting, simulcasting, or webcasting. Textbook of Legal Studies 12-2023-2024. www. CBCacademic. NIC. In 85. Unit I. Unit 2 UNITIII Unit IV. Unit V. Unit V Unit 7 Unit 8. 4. Right of adaptation, conversion, alteration, transcription, or rearranging a copyrighted work means and includes the right of adaptation. 5. Right to translate. The owner of the copyrighted work has a right to translate his work to any other languages. Moral rights. A moral right would stand a step ahead of an economic right. Moral rights are personal ties between an author and their work. They afford control over the creation and protect against modification or alteration, preserving the work's integrity. It includes the following. 1. Right of paternity. The right of an owner of copyright to claim and prevent others to claim the ownership of his copyrighted work is said to be a right of paternity. 2. Right of integrity. The right of the owner of the copyright to protect the reputation of his own work from exploitation is the right of integrity. 3. Right to retraction. Retraction is an act of taking back the previous assertion made. Case discussion. Amarnath Sehgal v. Union of India, 117, 2005, DLT 717. Amarnath Sehgal, a renowned sculptor, was commissioned to create a mural for the Indian government at Vigyan Bhavan. He spent 5 years creating the work and it was displayed in 1962. Without notification or consent, the Government of India removed the mural during renovations and stored it, causing some damage. Amarnath sued the government for violating his moral rights by mistreating his work. The Honorable Delhi High Court stated that moral rights, which define the essence of an author's work, cannot be taken away from the author, even if the work is sold. Destroying or altering the work was deemed a violation of the author's moral rights. Why is this protection required in modern society? Copyright is required in modern society to provide legal protection for creators of original works, such as literature, music, software, and art. This protection helps to ensure that creators are fairly compensated for their work and that their work is not used or copied without permission. Copyright also promotes creativity and innovation by giving creators the exclusive right to control the use and distribution of their works. Copyright plays a role in stopping plagiarism by providing legal protection for original works and giving the creators exclusive rights to control the use and distribution of their work. This protection helps to ensure that creators are fairly compensated for their work and that their work is not used or copied without permission. When someone is found to have plagiarized, they can be held liable for copyright infringement, which can result in legal action, fines, and other consequences. However, it is important to note that not all instances of plagiarism are necessarily copyright infringement, as copyright law only applies to original works that are fixed in a tangible form. Case discussion. Eastern Book Company and others v. D.B. Modak and another, Air 2008 SC 809. The extent of originality necessary to obtain copyright protection was the subject of inquiry. The Eastern Book Company brought a case to court against the defendants, Spectrum Business Support Limited and Regent Datatech Pvt Limited, for alleged infringement. The plaintiff, a renowned publisher, alleged that the aforementioned defendants had infringed its work, a publication of Supreme Court orders and judgments, known as SCC, in a substantial manner. The defendants, in turn, argued that there is a minimal level of creativity involved in such work, thus it is not eligible for copyright protection. Therefore, the respondent argues that the petitioner cannot bring legal proceedings based on copyright protection. The Supreme Court held that the inputs put in the original text by the appellants in segregating the existing paragraphs in the original text by breaking them into separate, Textbook of Legal Studies 12-2023-2024. www. CBCacademic. NIC. In. Unit I. Unit 2. UNITIII. Unit IV. Unit V. 86. Unit V. Unit 7. Unit 8. Paragraphs. E. Adding internal paragraph numbering within a judgment after providing uniform paragraph numbering to the multiple judgments. And E. Indicating in the judgment the judges who have dissented or concurred by introducing the phrases like concurring, partly dissenting, dissenting, supplementing, majority expressing no opinion, etc. have to be viewed in a different light. The task of paragraph numbering and internal referencing requires skill and judgment in great measure. The editor who inserts para numbering must know how legal argumentation and legal discourse is conducted and how a judgment of a court of law must read. In these inputs put in by the appellants in the judgments reported in SCC, the appellants have a copyright and nobody is permitted to utilize the same. Patent. What is a patent? A patent is a legal document which is issued by the government to the inventor. The patent grants an inventor absolute and exclusive ownership right over the invention, the freedom to use and sell the invention for a stipulated time period. It is a statutory right for an invention granted for a limited period of time to the patentee by the government, in exchange of full disclosure of his invention for excluding others from making, using, selling, importing the patented product or process for producing that product for those purposes without his consent. What is the term of a patent in the Indian system? The term of every patent granted in India is 20 years from the date of filing of application. Which act governs the patent system in India? The patent system in India is governed by the Patents Act, 1970, number 39 of 1970, as amended by the Patents Amendment Act, 2005 and the Patents Rules, 2003. What can be patented? Before getting an idea patented, the inventor must ensure its patentability. There are 3 requirements which are required to be fulfilled for an idea to qualify as a patentable matter. A. Novelty. The invention must contain one or more unique and new elements. B. Non-obviousness. Simple or obvious changes to an existing invention cannot be called an invention. The invention must be a notable change in the field. The particular feature must add to existing technical knowledge, that is, in terms of uniqueness and commercial viability. And C. Industrial application. The invention must have some utility. The invention is patentable if it is capable of commercialization. The purpose of patent law is to encourage scientific research, new technology, and industrial progress. Here are a few interesting patents granted in India. Memory cells, semiconductor devices, and methods of fabrication. This is a remarkable achievement by Gurtej Sandhu. His numerous inventions in the field of semiconductor devices and fabrication methods demonstrate his expertise and creativity in this area. He has filed over 1170 patent applications and is known as the Indian owning the highest number of patents. His recognition as one of the most prolific inventors in the world is a testament to his contributions to the field of semiconductor technology and his impact on the industry. Textbook of Legal Studies 12-2023-2024. www. CBCacademic. NIC. In 87. Unit I. Unit 2 UNITIII Unit IV. Unit V. Unit V, Unit 7, Unit 8. Sushant's breathing sensor apparatus. This is an interesting invention and highlights the potential of technology to improve the lives of people with disabilities. The breathing sensor apparatus is a unique solution that allows people with disabilities to perform tasks independently, using only their breath. The successful pilot testing and commercialization of the device demonstrate the potential for this technology to have a real impact on people's lives. The collaboration between Sushant Patnaik and the National Innovation Foundation is also noteworthy, as it highlights the importance of partnerships between inventors and organizations in bringing innovative ideas to market. These patents showcase India's innovation and creativity in a variety of fields and demonstrate the importance of intellectual property protection in promoting and rewarding innovation. 7. Trademark. What is a trademark? A mark is a distinguishing symbol which any person can use to exert public attention or to create some kind of impression in the minds of the people. Trademark is a brand entity which has a capability to distinguish one's goods and services from another person's goods and services. Trademark includes word, design, logo, shape of goods, their packaging and combination of colors. Trademark rights in India are statutorily protected by the Trademark Act, 1999. What is the function of a trademark? A. It identifies the goods or services and its origin. B. It guarantees its unchanged quality. C. It advertises the goods or services. D. It creates an image for the goods or services. Who benefits from a trademark? The registered proprietor of a trademark can create, establish and protect the goodwill of his products or services. He can stop other traders from unlawfully using his trademark, sue for damages and secure destruction of infringing goods and/or labels. Trade name. A trade name is the official name under which a company operates and is also known as a doing business as name or assumed name. On the other hand, a trademark is the name, symbol, logo, slogan or sound that a business uses to market its products and services. It is a unique identifier that helps consumers differentiate the products and services of one company from those of another. Both trade names and trademarks are important elements of a company's brand and play a crucial role in building and protecting the company's reputation and identity. The difference between a trade name and a trademark. A trade name does not provide brand name protection on its own, but registering it is an important step in protecting the name. On the other hand, a trademark provides protection for a brand name and helps to distinguish a company's products and services from those of others. In many cases, a company's trade name becomes its trademark, such as the example of Google. Registering a trademark offers additional protection and helps to secure the brand's identity. Textbook of Legal Studies 12-2023-2024. www. CBCacademic. NIC. In. Unit I. Unit 2. UNITIII. Unit IV. Unit V. 88. Unit V. Unit 7. Unit 8. Trade secret. Trade secrets can include a wide range of confidential information that is important for the success and survival of a business. This information can be in the form of strategies, designs, client databases, formulas, programs, or any other confidential information that must be kept secret to maintain the competitive advantage of the business. As per a landmark decision by the Delhi High Court of Burlington Home Shopping PVT. V.S. Rajneesh Chibbar, 1995, 35, DRJ 335. In 1995, a trade secret is defined as any information with commercial value, which is not available in the public domain and the disclosure of which would cause significant harm to the owner. The trade-related aspects of intellectual property rights, TRIPS, agreement from the same year defines trade secrets as information which is kept secret, has a commercial value and the owner of the information takes reasonable steps to keep it secret. There is no specific legislation that provides protection for trade secrets, but they can be protected under various provisions of different statutes, such as Section 272 of the Contract Act, 1872. Indian courts have also recognized trade secret protection based on equity principles and common law remedies for breach of confidence and breach of contract. To ensure the protection of trade secrets, it is important for businesses to include restrictive clauses in their service contracts. This helps to secure the confidentiality of the firm's trade secrets and prevent unauthorized disclosure. 8. Geographical indication. What is a geographical indication? A geographical indication, GI, is a legal designation that identifies a product as originating from a specific region or geographical location and having certain qualities, characteristics, or reputation that are unique to that place. GI protects the product's authenticity and quality and helps consumers identify the product's origin and reputation. It is a name or sign used on certain products which corresponds to a geographic origin of the product. The relationship between objects and place becomes so well known that any reference to that place is reminiscent of goods originating there and vice versa. The Geographical Indications of Goods, Registration and Protection Act, 1999 provides for registration and better protection of geographical indications relating to goods in India. Textbook of Legal Studies 12-2023-2024. www. CBC Academic. NIC. In 89. Unit I. Unit 2 UNITIII Unit IV. Unit V. Unit V Unit 7 Unit 8. Examples predict geographical origin Fulkari Handicraft Punjab, Haryana, Rajasthan. Worli Painting Maharashtra, Gujarat, Daman and Diu Malabar Robusta Coffee Kerala and Karnataka Darjeeling Tea West Bengal Pochampalli Ikkat Telangana. Geographical origin. Geographical origin refers to the specific place or region where a product or item originates from. This can include the location where raw materials are sourced, where production takes place, or where a particular process or technique is used to create the product. Geographical origin can have a significant impact on the quality, reputation, and cultural identity of a product and is often used as a way of distinguishing and promoting products with unique characteristics and qualities. In some cases, geographical origin is also protected by intellectual property laws, such as geographical indications. X. Designs. What is a design? Design intellectual property refers to original and unique creations of the mind that can be used commercially. The Designs Act, 2000 is the law relating to the protection of designs in India. The law helped creators earn recognition and financial benefits for their products, and also help prevent others from using their creations without permission. A design right protects the original and aesthetically unique appearance of a manufactured item, as long as it is new and not obvious. This type of protection only covers the ornamental aspects and does not extend to the functional or structural elements. Any design invented by a person shall be protected by designs. Shape, color, line, pattern, etc. are covered under designs. A design may not be eligible for registration if it lacks individual character, is considered offensive, or if its appearance is solely dictated by its function. These criteria are used to assess the registrability of a design and ensure that it meets the necessary standards for protection under intellectual property law. Example: design of the wrapper of a biscuit or chocolate, design of a car, design of the shape of a cold drink bottle, etc. X. Conclusion. Intellectual property rights, IPR, are exclusive rights to individuals for a limited time period, allowing them to exploit income from cultural expressions and inventions. Proponents of IPR provide three commonly accepted reasons for society to grant such privileges. When someone creates a new product, it takes a lot of time, money, and effort. It's only natural for the inventor or organization to want to own exclusive rights to the invention, so that others can't benefit from it without permission. It encourages creativity and innovation by granting economic benefits to the creator. Textbook of Legal Studies 12-2023-2024. www. CBC Academic. NIC. In. Unit I. Unit 2. UNITIII. Unit IV. Unit V. 90. Unit V, Unit 7, Unit 8. It promotes economic growth through competition and protection of rights. These rights are necessary to protect the global intellectual property rights in today's world. The management of intellectual property, IP, and intellectual property rights, IPR, is a complex task that requires a combination of functions and strategies, aligned with both national laws and international agreements. It can no longer be solely approached from a national perspective. Forms of IPR can vary and require varying approaches, including specialized knowledge in areas such as science, engineering, medicine, law, finance, marketing, and economics. The handling and management of these forms of IPR involve different strategies and require consideration of their social, economic, technical, and political impacts. The rapid pace of technological advancement, globalization, and intense competition have made it necessary to protect innovations through IPRs like patents, trademarks, copyrights, and trade secrets. Despite these measures, infringement of intellectual property rights still occurs. The government has laws in place to prevent such violations and is taking action to enforce them. Exercises. Based on your understanding, answer the following questions. 1. What is meant by intellectual property? Why does intellectual property need to be promoted and protected? 2. Discuss the concept of national treatment and its evolution through the various international conventions on intellectual property rights. 3. Describe copyright and the works protected under Copyright Act. 4. You are an author who has written a novel in Hindi. The novel has become immensely popular and now podcasters, serial producers and YouTubers are trying to adapt the story to be telecast on various forms of media. There are some authors who also want to translate your novel into English. Discuss how you will negotiate in this situation given that you have certain economic rights as a copyright owner. 5. There was a recent tiff between the states of Orissa and West Bengal over the origin of the ever-popular sweet dish, Rasgulla. Both states argued that the Rasgulla had been invented in their respective states. However, the registrar of the Chennai Ghee office gave the ghee tag to the Banglar Rasgulla of West Bengal. This caused a rift between the states as both were competing to get the ghee tag for Rasgulla for their respective states. In light of the above case, discuss. What rights does a geographical indication provide? How would Orissa be adversely affected by the order of the Chennai Ghee office? B. For which types of products can ghee tags be used? 6. Valganciclovir hydrochloride is a medicine that is stable when stored as a solid state under normal conditions. The applicant tried to make a liquid form of the medicine, but it was unstable for the required shelf life. Therefore, they focused on a powder form that could be mixed with water to make a liquid form. The powder form was very similar to the solid form and their patent claim was rejected. Discuss why the patent claim was rejected in view of the essential ingredients of a successful patent claim. Textbook of Legal Studies 12-2023-2024. www. CBCacademic. NIC. In 91. Unit I. Unit 2 UNITIII Unit IV. Unit V. Unit V Unit 7 Unit 8. Activity-based questions. 1. When we eat a burger from a renowned chain or drink a bottle of branded cola, we are consuming IP. From trade secrets like the Coca-Cola's original recipe to registered designs like Nike's tick mark, IP protects products, ideas and experiences that we consume every day. In order to show students that IP is all around us, the students can conduct an IP treasure hunt. The teacher will set a timer and have students look around the classroom for brand names, trademarks, registered designs or patents. If they read a book, watched a video or listened to a song today, even then they have interacted with IP. Award a prize to the student with the most surprising discovery or the highest number of discoveries. 2. You are setting a new cold drink manufacturing company with new and innovative machineries and recipes. You plan to use your knowledge of IPR to safeguard your new company from old big shot companies as well as new budding companies. Describe in details what all rights you will register and how you will benefit out of it. Bibliography 1. Web links 2. Web links 3. Amarnath Sehgal v. Union of India 117, 2005, DLT 717-4. Eastern Book Company and others v. D.B. Modak and another, Air 2008 SC 809-5. Burlington Home Shopping PVT. V.S. Rajneesh Chibbar, 1995, 35, DRJ 335-6. Web links, Textbook of Legal Studies 12-2023-2024. www. CBCKdemic. NIC. In. Unit I. Unit 2. UNITIII. Unit IV. Unit V. 92. Unit V. Unit 7. Unit 8. Unit 4. Law 2. General Laws. Textbook of Legal Studies 12-2023-2024. www. CBCKdemic. NIC. In 95. Unit I. Unit 2. Unit 3. UNITIV. UNITV. Unit V. Unit 7. Unit 8. Law and Sustainable Development. A. Introduction. What is sustainable development? Sustainable development is defined as economic development that meets the needs of the present without compromising the ability of the future generations to meet their own needs. United Nations General Assembly, 1987. The aim of sustainable development is to achieve long-term economic growth by lowering the impact on the environment by reducing air, water and soil pollution, so that a better life is ensured for the future generations. Few examples of sustainable practices are harnessing solar energy to reduce pollution in the environment and planting different types of crops on the same land on a rotational basis for improving soil fertility. What is sustainable development in law? Sustainable development is an approach to economic planning that attempts to foster economic growth while preserving the quality of the environment for future generations. What are Sustainable Development Goals, SDGs? The Sustainable Development Goals, SDGs, are a collection of 17 interlinked goals that provide a shared blueprint for peace and prosperity for people and the planet, now and into the future. SDGs are also known as global goals. The SDG framework was adopted by the United Nations in 2015 as a universal call for action to protect the planet, end poverty, and ensure that all people enjoy peace and prosperity by 2030. To achieve SDGs, the creativity, know-how, technology and financial resources from all of society are necessary. Chapter 4, A. Textbook of Legal Studies 12-2023-2024. www. CBCKdemic. NIC. In. Unit I. Unit 2. Unit 3. UNITIV. Unit V. 96. Unit V. Unit 7. Unit 8. The 17 Sustainable Development Goals, SDGs, to transform our world are: Goal 1, No Poverty. Goal 2, Zero Hunger. Goal 3, Good Health and Well-being. Goal 4, Quality Education. Goal 5, Gender Equality. Goal 6, Clean Water and Sanitation. Goal 7, Affordable and Clean Energy. Goal 8, Decent Work and Economic Growth. Goal 9, Industry, Innovation and Infrastructure. Goal 10, Reduced Inequality. Goal 11, Sustainable Cities and Communities. Goal 12, Responsible Consumption and Production. Goal 13, Climate Action. Goal 14, Life Below Water. Goal 15, Life on Land. Goal 16, Peace and Justice. Strong Institutions. Goal 17, Partnerships to achieve the goal. Stockholm Declaration, 1972. The Stockholm Convention is a global treaty that aims to protect human health and the environment from the effects of persistent organic pollutants, POPs. It was the first convention to discuss environmental issues on a global scale. The declaration proclaims truths relating to man and the environment, such as man as the creator and molder of his surroundings. The declaration also reiterates the importance of preservation of the environment. B. Initiatives under international scenario. A. Rio Declaration 1992. Agenda 21. The United Nations Conference on Environment and Development, UNCED, also known as the Earth Summit, was held in Rio de Janeiro, Brazil in 1992. The conference marked the 20th anniversary of the first ever International Human Environment Conference in Stockholm, Sweden, 1972. The conference was attended by representatives from 179 countries to discuss the impact of human socio-economic activities on the environment. The objective of Rio Earth Summit was to formulate a blueprint for global action on environment and development issues. It recognized that integrating and balancing the economic, social, and environmental concerns in meeting our needs is vital for sustaining human life on the planet Earth. This triggered action on part of governments from across the globe on how to ensure sustainability with development. The Earth Summit resulted in some major actions by countries from across the globe in the form of conventions and resolutions. To name a few: Agenda 21, UNFCCC, United Nations Framework Convention on Climate Change, Convention on Biological Diversity, the Declaration on the Principles of Forest Management, Commission on Sustainable Development, Textbook of Legal Studies 12-2023-2024. www. CBC Academic. NIC. In 97. Unit I. Unit 2. Unit 3 UNITIV UNITV. Unit V Unit 7 Unit 8. B. Agenda 21. Agenda 21 was one of the most daring programs calling for action strategies. It focused on new methods of education, new ways of preserving natural resources, and new ways of participating in a sustainable economy. The implementation of Agenda 21 was reaffirmed in the World Summit on Sustainable Development held in Johannesburg, in 2002. Agenda 21 focuses on community participation as one of the major prerequisites for sustainable development. Attaining sustainability therefore requires addressing the fundamental issues and challenges pertaining to development at local, regional, and global levels simultaneously by all segments of society. Thus, the key objective of sustainable development being to improve human well-being and to sustain these improvements over a period of time, remains the focus of Agenda 21. C. Provisions under Indian Constitution. A. Constitution of India. The Constitution of India under Article 21 enshrined the right to life. This article in its wider interpretation encompasses right to clean environment as an important facet of life. Further, Article 38 shoulders the state with the responsibility of maintaining social order for ensuring a welfare state. This is only possible with the people living in a pollution-free environment. Article 48A, inserted by the 42nd Amendment to the Constitution of India, states, protection and improvement of environment and safeguarding of forests and wildlife. The state shall endeavor to protect and improve the environment and to safeguard the forests and wildlife of the country. It requires the state to adopt the protectionist policy as well as improvinistic policy. Protectionist policy imposes ban on those things which lead to environmental degradation, e.g. ban on use of leaded petrol, ban on use of plastic bags, etc. Improvinistic policy refers to alternatives that can be used for improvement of environment, e.g. use of CNG or low sulfur fuel, tree plantation in industrial areas, etc. A duty has also been imposed on all citizens to protect our environment. Article 51A, G, of the Indian Constitution says, it shall be the duty of every citizen of India to protect and improve the natural environment including forests, lakes, rivers and wildlife, and to have compassion for living creatures. B. Legal mechanism. The Constitution of India clearly endows a duty on the state to protect and improve the environment and to safeguard the forests and wildlife of the country. To strengthen environment protection at grassroots level, it further imposes fundamental duty on every citizen to protect and improve the natural environment including forests, lakes, rivers, and wildlife. The state, indispensably, has been directed by way of provision under Part 3 and Part 4 to ensure the protection of environment by suitable legislations, regulations and otherwise. The Honorable Supreme Court in K. M. Chinnappa vs. Union of India defined environmental law as an instrument to protect and improve the environment and control or prevent any act or omission polluting or likely to pollute the environment. It is with the enactment of Environment Protection Act, 1986 that a concrete step has been taken. Textbook of Legal Studies 12-2023-2024. www. CBCacademic. NIC. In. Unit I. Unit 2. Unit 3. UNITIV. Unit V. 98. Unit V. Unit 7. Unit 8. For combating modern day challenges in environment protection and improvement. Prior to the enactment of the Act, environment protection regime was more regulatory in nature. At present, environment protection in India comprises of the following legislations and regulatory bodies. C. Legal framework. 1. Environment Protection Act, 1986 2. Air Prevention and Control of Pollution Act, 1981 3. Water Prevention and Control of Pollution Act, 1974 4. The Noise Pollution Regulation and Control Rules, 2005. National Green Tribunal Act, 2010 6. Energy Conservation Act, 2001. D. Environment Protection Act, 1986. In the wake of the Bhopal tragedy, the Government of India enacted the Environment Protection Act of 1986 under Article 253 of the Constitution. The purpose of the Act is to implement the decisions of the United Nations Conference on the Human Environment, relating to the protection and improvement of the human environment and the prevention of hazards of human activities for economic development to human beings, other living creatures, plants and property. The Act is an umbrella legislation designed to provide a framework for the central government to coordinate the activities of various central and state authorities established under previous laws, such as the Water Act and the Air Act. India, like any other developing nation, is facing an alarming concern in environmental degradation due to economic activities. Control mechanisms to guard against slow, insidious buildup of hazardous substances, especially new chemicals, in the environment are weak. E. Pollution Control Board. A. The Central Pollution Control Board. The Central Pollution Control Board is a statutory organization under the Ministry of Environment and Forest Protection. It is constituted under the Water, Prevention and Control of Pollution Act, 1974. Principal functions of the CPCB have been spelled out in the Water, Prevention and Control of Pollution Act, 1974, and the Air, Prevention and Control of Pollution Act, 1981. Its broad functions include promoting cleanliness of streams and wells in different areas of the states by prevention, control and abatement of water pollution, and by improving the quality of air and to prevent, control or abate air pollution in the country. However, if we analyze the functions in detail, they may be summarized as follows. Advise the central government on any matter concerning prevention and control of water and air pollution and improvement of the quality of air. Plan and cause to be executed a nationwide program for the prevention, control or abatement of water and air pollution. Coordinate the activities of the State Board and resolve disputes among them. Textbook of Legal Studies 12-2023-2024. www. CBCacademic. NIC. In 99. Unit I. Unit 2. Unit 3 UNITIV UNITV. Unit V Unit 7 Unit 8. Provide technical assistance and guidance to the state boards. Carry out and sponsor investigation and research relating to problems of water and air pollution, and for their prevention, control or abatement. Plan and organize training of persons engaged in program on the prevention, control or abatement of water and air pollution. Organize through mass media a comprehensive mass awareness program on the prevention, control or abatement of water and air pollution. Collect, compile and publish technical and statistical data relating to water and air pollution and the measures devised for their effective prevention, control or abatement. Prepare manuals, codes and guidelines relating to treatment and disposal of sewage and trade effluents as well as for stack gas cleaning devices, stacks and ducts. Disseminate information in respect of matters relating to water and air pollution and their prevention and control. Lay down, modify or annul, in consultation with the state governments concerned, the standards for stream or well, and lay down standards for the quality of air. And perform such other functions as may be prescribed by the Government of India. B. The State Pollution Control Boards. State Pollution Control Board is a statutory organization established under the Water, Prevention and Control of Pollution, Act 1974, which works under the supervision of the Central Pollution Control Board to implement the environmental laws and rules within the respective state for the protection of the environment. It is mandatory for every business, either new or existing, to obtain necessary authorization from the respective State Pollution Control Board in order to carry out the activities of the business in a state. Objectives: preservation of natural resources, promotion of sustainable development for economic growth of the nation along with environmental protection and social equity, effective waste management for the protection of the environment. Spreading awareness about the protection of the environment among the consumers, encouraging the general public for the use of environment-friendly products like paper bags, public transport, CFL, etc. To help reduce the environmental pollution. Functions of the board. The broad functions of the board are in line with the functions of the central board and aimed at the prevention, abatement, and control of air and water pollution. Moreover, the primary motive is to assist the entrepreneurs and industries in the fulfillment of corporate environmental responsibility, SER. The functions of the board can be detailed as follows for further understanding. Issue NOC, no objection certificates, from the perspective of the environmental pollution, including the adequacy of the site from the environmental angle. Textbook of Legal Studies 12-2023-2024. www. CBCacademic. NIC. In. Unit I. Unit 2. Unit 3. UNITIV. Unit V. 100. Unit V. Unit 7. Unit 8. Assessment of quality ambient air. Assessment of inland surface waters quality, issuance of the consent under provisions of Section 21 of the Air, Prevention and Control of Pollution, Act, 1981. Issue of consent under provisions of Section 25-26 of the Water, Prevention and Control of Pollution, Act, 1974. Collection and assessment of water cess, under the provision of Water, Prevention and Control of Pollution, Cess Act, 1977. Assessment and identification of municipal and industrial pollution sources and control. Conducting mass awareness programs. Development of pollution control technologies. Notification of emission and effluent standards. Instituting legal action against defaulters. Implementing biomedical waste rules, 1998. Issuance of authorization under the Hazardous Waste Management Rule, 1989. Identifying the on-site crisis management plans, isolated storage, etc. Under the Manufacture, Storage and Import of Hazardous Chemicals Rules, 1989. SDGs can be the most useful weapons to build the economies in such a way that they can provide for the future generations in a sustainable way. All countries must work together to achieve these goals and create a sustainable world. India has put together a legislative framework for the attainment of these goals. What is needed now is a strong implementation of these laws to achieve a better relationship between the society and environment. Exercises. Based on your understanding, answer the following questions. 1. What is the meaning of sustainable development? What does it aim to achieve? 2. When and why was the SDG framework adopted? How can these SDGs be achieved? 3. Identify the SDG goals which provide for protection of environment. 4. Describe the legal framework in India for environment protection. 5. What are the main functions of A. Central Pollution Control Board. B. State Pollution Control Board. Bibliography 1. Web links 2. Web links 3. Web links 4. Blog. Ipleaders. In 5. Web links 6. Web links, Textbook of Legal Studies 12-2023-2024. www. CBC Academic. NIC. In 101. Unit I. Unit 2. Unit 3 UNITIV UNITV. Unit V Unit 7 Unit 8. Forms of legal entities. Learning outcomes. Students will be able to identify different forms of business entities, organizations, explains features, merits and limitations of different forms of business entities, organizations, distinguish between various forms of business entities, organizations, discuss the factors determining choice of an appropriate form of entity, organization. I. Introduction. If one is planning to start